Our next speaker is Rejo Zenger from Bits of Freedom. And when we put out the call for presentations, Rejo was one of the very first to respond, saying, "Hey, can I share some insights into recent developments in laws that are being proposed or being passed?" And I said, "That is fantastic. But whatever you do, please just use a PDF that you email to us ahead of time. Do not use your own laptop."
I want freedom.
So Rejo put down his foot, saying, "I will bring my own laptop."
Shit.
And I thought to myself, surely this will be the only person that does this trick. But there will be 4 more laptop slots later today.
Oh nee, niet nodig, sorry.
After Rejo finishes his presentation, we'll visit each of you and take a copy of your passport for administrative reasons.
Nee, het gaat niet meer werken zo. Wacht, ik pas het zelf aan. Uploaden aan. Daar. Cool.
Are you ready to rock?
Sure.
The floor is yours. Rejo Zenger.
So, thanks for having me. So, I'm Rejo Zenger and I work for the Dutch digital civil rights organization Bits of Freedom. But I don't think I'm telling you something new here. So, I'm going to talk about some horror from Brussels, just like last year basically. I will be discussing the latest proposal from Brussels, but before I do that, I'll get back to I'll give you an update on the topic I was discussing last year. So that talk is still, so the topic of that talk that is still being very relevant to this day. So I was discussing the encryption debate in Europe and where many countries feel the need to propose legislation for backdoors to circumvent the encryption. And I mentioned the so-called e-privacy reform, and that's a piece of legislation that is in a way an addendum to the forthcoming new privacy rules, the General Data Protection Regulation. And it focuses on privacy issues, so the new legislation that is being debated right now, that focuses on issues specifically on the use of digital tools like your phone. Should a company be allowed to track you on the streets based on your Wi-Fi or Bluetooth signal? Or what are the conditions under which cookies are permissive? Sorry, I need to switch quickly. So one of my big worries was this. Although the rules are meant to guarantee the confidentiality of your digital communications, member states can add an exception to that rule for law enforcement. And that in itself may not be too bad. There are circumstances, or maybe circumstances, where we as a society think it is acceptable that an internet connection is being intercepted by the police or the intelligence services. And in the Dutch translation of these European rules, the legislation also states that if a connection is being intercepted by the police and the provider is involved in applying some form of encryption, the provider needs to provide a decrypted stream to the police. And I think that is reasonable as well, because, or at least that's reasonable for the sessions where the provider is involved in the application of the encryption. So for example, in an S&P session, if the provider is on one end of the encryption, I think it's fair to ask from the ISP to remove the encryption when intercepting that S&P traffic. And end-to-end encryption is safe there because the provider, of course, doesn't have access to the key material used for the end-to-end encryption by the clients. But that is about to change. So the European Commission wants to extend the rules on confidentiality of digital communications from traditional providers to over-the-top services like WhatsApp. And there's definitely something to say for that approach, because for the average Joe, I don't think there's much of a difference between an SMS, which by current rules, the confidentiality is protected, and a WhatsApp message for which there's no protection under the current rules. But there's a catch. So WhatsApp also controls the software that runs on the end user's equipment. Now, if we blindly apply the logic of the current rules to the proposed ones, there's a negative consequence of that extended application to over-the-top services. The rules are meant to guarantee for confidentiality, but also allow for exceptions for law enforcement. Now, if that also implies that the provider of the over-the-top services should remove the encryption that is applied, then this may lead to the removal of the end-to-end encryption on the client's device. And that is because, of course, unlike a traditional provider, WhatsApp does have access to the code on your phone. So if we extend the rules of confidentiality to over-the-top services, and we leave the exception to that rule in place, just like as we have it now, end-to-end encryption in over-the-top services is broken. So to mitigate, Bits of Freedom has proposed an amendment. And the amendment says something, I'm not quoting it here because it's way too long and way too legal, but it says something along the lines of the exception does not allow for interference on the information on the end user's device. So basically, we're proposing an exception to the obligation. But if that's what it takes to protect your freedom, I'm happy with that. And will that proposal make it to the actual legislation? We don't know yet. Because although I was talking about this legislation last year, the votings on that piece of legislation are expected somewhere in October. So maybe next year, another update. Now let's get to the back to the topic, the initial topic of this this talk. It was titled, "Did you know that EU lawmakers want to make you responsible for your customers' data?" Or, to put it differently, the European Commission's approach, death to memes. So in the next 15 minutes, I will quickly talk about the current framework on liability of intermediaries, on liability of providers, the proposed changes to this framework, which includes an upload filter, and your role in all of this. So the current framework on liability of intermediaries. That already sounds fairly legal. Sorry about that. So the current framework is fairly simple. You are liable for whatever is published on your platform, to put it very, very bluntly. There are, however, 3 sensible exceptions to this rule. You're not responsible for the transmission, the caching, and hosting of information of others. Each of these comes with a set of requirements. For example, you're not liable for the transmission of information of others, provided the transmission is initiated by someone else. You do not select the receiver, and you do not interfere with the information that is transmitted. So you should not select or modify that information. Similar requirements apply to the hosting of information as well. So, for example, you are a platform, you're hosting a platform where which facilitates the hosting of user-generated content. You are not liable as long as you are not aware of the infringing character of some piece of information. So you're not liable as long as you don't know about a user that has uploaded the latest blockbuster that is still that still needs to hit the cinemas. But whenever you become aware, you expeditiously need to remove or disable access to that information. And this is where the famous notice and takedown procedures come from, or as the European Commission's approach to that, the notice and stay down approach. It works on the presumption that the hosting provider does not know about the infringement of that a user has made, but upon notification, the provider is aware and needs to act. If you do not act in that case, then you will become liable for that infringing content. And then there's one more article in this piece of legislation that is very relevant to providers. Article 15 of this e-privacy directive makes clear that the governments are not allowed to impose a general monitoring obligation. So the Dutch government is not allowed to create a piece of legislation that says content hosting providers need to check everything that the user is uploading. A provider may not be forced to monitor all of the information that he is transmitting, caching, or hosting in order to find illegal activity of the user. And I think that these safe harbors have been very important for the growth of the internet in the last decade. If you're a hosting platform, but at the same time you have to worry about all of the uploads of your users, you will be probably very restrictive in whatever you will allow your users to publish on your platform. And probably you would start monitoring all of your users' uploads preemptively to avoid being held liable for an illegal upload of one of your users. And as we all know, cute little cats have been doing very, very well in this environment. So there's a new proposal. The proposal was made last year when the European Commission published a review of the copyright directive. And there's this one article in the proposal that has seen way too little attention so far, I think, but is a disaster to the internet as we know it. It will, if enacted, completely change the way providers and platforms think about user-generated content. And as I said, I think it means the end to memes on the internet. So first of all, the article would introduce an obligation for platforms to install an upload filter with which to monitor all uploads users are making. The obligation would apply to all information society service providers that store and provide access to large amounts of works uploaded by their users. And such a filter should use effective content recognition technology to identify illegal uploads. And the filter should work based on the input provided by rights holders. So what does this mean? It means that all larger platforms are required to monitor all uploads of all users. And as the definition of many of the phrases are in the legislative proposal are not very clear, this does, I think, not only apply to YouTube or Facebook, but it also could apply to SoundCloud or even GitHub or maybe even a colocation provider. So the operation of the filter is a responsibility of a legal responsibility of the provider, but it's kind of weird that at the same time it's the right holders that dictate what is acceptable or not. So as a provider you would need to trust blindly the rights holders to tag the correct information to be unacceptable to be published. And copyright, at first sight, is a fairly binary thing. So, or you have the permission to publish some piece of information, or you don't. But then there are many exceptions to this rule as well, like, for example, citation, parody, or education. It'll be difficult for automated filters to properly judge the context within which the information is published. In other words, it will be hard for a filter to tell whether the fragment of some episode of a movie or a TV series is an infringing copy or whether it is used in a parody. There are many court cases about these kind of exceptions, and it takes judges a considerable amount of time to make a good judgment. So I'm wondering how to expect an automated filter to make a judgment in a flip second. In other words, the filter will most likely overblock. And then there's more. In case the provider does not recognize the use of some protected work in the upload of the user, they may be held liable for not blocking that upload. And I'm pretty sure that has severe consequences. Many of the companies will understandably say better safe than sorry. It's better to block users from uploading content that is potentially infringing, although it may be illegal. So it's better to block the users from uploading content that's potentially infringing someone else's rights, instead of risking being held liable for making that content available. And actually, to make sure that the risk is minimized, I guess that companies will preemptively restrict the types of content users are allowed to publish on their service. And they can easily do that by updating their acceptable use policies, which no one reads, of course. And of course, the policymakers drafting this proposal did spend an afterthought on the position of the internet user. Because they do recognize the risk of overblocking, the proposal also requires companies to implement a redress mechanism. And in practice, I don't think this will help a lot for two reasons. First of all, such a process will take too long for time-sensitive information. If you want to publish a vlog with political criticism, while including some copyrighted content, it will be blocked, and getting it unblocked will take, let's say, 48 hours. But then your momentum is gone, obviously. And secondly, anything that is blocked on the acceptable use policy basis, which will be a lot, I presume, will not be directly blocked based on this piece of legislation, and therefore the redress mechanism will not fire. So to summarize, the proposed copyright directive will introduce an upload filter for many or even all of the platforms hosting a considerable amount of user-generated content. This filter is used to monitor all uploads of all users. And although the filter runs on data provided by the rights holder, so the filter is controlled basically by the rights holders, it will be under the legal responsibility of those platforms running the filter. And these platforms will be held liable if they fail to block copyrighted content. In the long run, I guess the freedom of expression will be harmed as much as such filters will not be able to recognize the legal use of exceptions in copyright. We'll end up with a scanned version of the internet, an internet without memes. So there only seems to be one clear answer to this proposed legislation, right? If the European Commission proposes an upload filter and wants to make intermediaries liable for whatever the users are publishing on the platform, you would expect strong opposition. And that is actually the case. I've yet to find a sign-on letter by academics or companies that is in favor of this legislation, of course, other than the big publishers and some record labels. But no, reality is kind of different here. The European Parliament still has to make up its mind. But the votings in some of its subcommittees in the past may allow for some optimism. In the process, there have been many horrible proposals for amendments to this proposal of the European Commission. Take, for example, one of the amendments in the second most important committee of the Parliament, dubbed an alternative compromise. The amendment of a member of the political party of the EPP would have made the text even worse. The upload filter would have been applied to all services hosting content of users, regardless of their size. I think he did include a 2-year waiting period, but if your service was older than 2 years, you were required to install an upload filter. And the content filter, if this amendment would have been approved, was also to be applied to services not hosting at all, such as search engines just linking to possibly infringing content. In other words, a content filter on steroids. And it's not just the European Parliament that seems to take the European Commission's proposal as a starting point. Last week, a proposal of the Estonian presidency to the Council of Europe was leaked. The Council is the representation of the member states, so the governments of the member states in Brussels. And they are the third institution that is involved in making legislation in Brussels. So there's the European Parliament, the European Commission, and the Council. And the leaked document from the Council included 2 alternative presidency compromise proposals. One of the proposals explicitly would have made both the user as well as the provider liable for the one and same copyright infringement. By the way, the Dutch government is doing well at this particular topic. I have to be positive about the Dutch government in this particular case. The Dutch have been critical about the initial proposal of the European Commission from the start. And another leak of last week showed that 6 member states, including the Netherlands, are questioning the legality of the proposal. The ministers from the Netherlands, Ireland, Belgium, Czech Republic, Finland and Hungary have asked whether the plans are in line with the European Charter of Fundamental Rights, which guarantees freedom of expression, protection of personal data and prohibits blanket surveillance. And I do understand their questioning, because if this is done wrong, this is not a directive that in a couple of years' time will be ruled invalid, just as we have seen with the data retention directive. but then of course the harm is already done. So where does it leave you? In case your business revolves around hosting user-generated content, there's obviously a reason to worry. Depending on the text that is finally adopted, it may put an obligation on you to develop or buy expensive user monitoring capabilities. It may put you in a position where you have to negotiate agreements with rights holders, such as big publishers or the record labels. And it may make you directly liable for the content that your users are uploading on your platform. So let's put it mildly, not the most comfortable position, I'd say. And in fact, I think we all have to worry. So even if you're not in the business of hosting user-generated content, you still have to worry. You see, this will have a huge impact on all users of the platforms, as it will impact your freedom of speech there. And that means that this piece of legislation has an impact on all of you. So you need to do something about this. But first of all, I think it's important to understand the dynamics of this European legislative process. Although the Netherlands is second, we are a fairly small member state and compared to the others. And in addition to that, the Dutch government is already fairly critical about this proposal. And that means that the largest impact can be made in other member states, such as Spain, Italy, France, and Germany. So to have an impact on negotiations in Brussels, it's best to target the policymakers in these large member states in Europe. So if you're working for a company operating on a European scale, make sure that not just your office, but also your office in the other member states are raising their voices against a censorship machine in the EU. And secondly, all of you can help by simply contacting the members of parliament in Brussels. In the weeks before each of the votings in the committees in the European Parliament, Bits of Freedom will update our campaign website named SaveTheMeme.net. The website allows users to make free calls to the members of parliament in Brussels, so you can easily and cheaply express your worries. And in order to help people making these calls very efficiently, we will select like in 10 to 15 members of parliament, which should be on your top list to make a call to. But for now, question everything I wanted to say. The next slides. Doesn't come. Anyway, question everything. Thank you.
Thank you, Rejo, for this update.
There must be questions. There's one.
Where does the asymmetry come from? With asymmetry, I mean that there is this companies that can claim ownership of some digital media that gets to become part of an upload filter, and as an end user that for whatever reason collides with that fingerprint. So I see this on YouTube quite often, where material that was in the public domain is flagged as this is owned by Sony, and Sony has its robots and is very efficient at flagging the material, but it's quite hard to fight back, and that's what I refer to as the asymmetry.
Yes, so a couple of comments about that. First of all, Sony does have a very efficient tool to flag material that they deem to be making an infringement. But this tool is that efficient that it also makes mistakes very frequently. So if you look at, for example, the MCA requests, you very often see record labels taking down their own content, or even flagging their, links to their own website, for example. So this illustrates, I think, how as a provider you cannot trust the record labels and publishers to provide you with the correct set of hashes of content that should be removed or blocked. The other thing is that it is, of course, very hard to create a process which allows for the user to fight against the blocking of some material, blocking some a video, for example, to make it very timely, to make it very fast. If the provider needs to take into account all of the rights involved, so the rights of the user, his own stakes, but also the rights holder. So that's a very difficult process, and that it is very difficult is shown by the fact that, first of all, for example, judges take a long time to make a decision themselves. They are supposed to be experts in this. They should be able to tell fairly quickly, what is legal and what is not. But because they can't, it shows how difficult it is. And so I don't really think that really does work the way we want it to work. And last comment I want to make here is that you were talking about, of course, Content ID, the tool that YouTube uses for flagging content, so for taking down content which is potentially infringing someone's rights. And this legislation seems to be written especially around Content ID. So if there is one company which does not have difficulties in following this new legislation, it is YouTube. YouTube already has everything in place to do this right. There may be some other companies which come close, so there are all the larger near monopolies we already have. And I think what this does is it will only strengthen their position, and it will weaken the current platforms that are like on a sub-level, like in the smaller ones, like SoundCloud or these kind of companies, and it will make it difficult for newcomers to enter that market. So I think that this piece of legislation, one of the effects it has, it will strengthen the position of the large platforms we already know, like YouTube, and it will make it difficult to change that. It will make it even more difficult to change that.
That was a very elaborate answer, thank you. Yep. First question from the line.
Hello, I'm Alexander Isavnin, guest from a friendly NLNOG from the East. Even in Russia, where is a content filtering system implemented already, such suggestions from copyright holders have been cancelled. So they wasn't able to push all this content filtering based on copyright issues. And this have not passed just because of simple question, who will pay for this? The copyright holders refused to pay, so this legislation did not get into the ruling, just because the bigger ISPs was possible to push it out. In your case, I hope, and I'm ready to discuss it, you are much more developed union. You also could protect this initiative from getting these initiatives into the life, just to suggesting responsibility for false takedowns. So if copyright holder takes down political speech because of his copyright and this false, he must pay as much as he would not like to do this. So I hope these initiatives will not get into life in the European Union.
Yeah. So two quick comments on that. First, I think so. The proposed legislation doesn't say anything about who needs to pay for what. So I guess that it means that the provider will have to pay for the filter, for the upload filter, which of course is a fairly expensive tool to add if it doesn't add anything else for your own business. That argument is being made that that the upload filter is now being expected that the provider is paying for it, and that we should shift the burden to the rights holders for doing that. But I'm not sure whether that will actually block this piece of legislation. And the other thing is, so the false notification, that's something which, of course, that problem already exists. I'm not sure whether it's easy to change that in our legislation, because, for example, in the Netherlands, you can only, what is schade? Damages. So the damages are often very, very small, and asking for damages doesn't really is not really a financial incentive to behave better. So that's kind of difficult, I think.
Ruben Stava, private internet citizen. Remark from my side is that I don't think any upload filter will be future-proof, as who can guarantee us that such means won't be subverted to be, for instance, included in blanket surveillance, for instance?
So I'm not sure whether I understood your question correctly, but you were talking about function creep as well, or?
Yeah, feature creep,
Yeah.
indeed.
So, of course, you see a lot of legislation is put forward based on intellectual property, but then in the course of time it will be extended to other areas as well. So my prediction for this would be, now it's about the copyright. In future it will include trademarks as well, so the fake bags and stuff like that, or fake clothing that is sold on a marketplace. If that is done, then of course it can be extended maybe for governmental purposes, like in fighting hate speech or terrorism related. And of course, so there are many, if this is installed, then I think in time the purposes for which it is applied will be extended as well.
Yes, exactly that.
Yeah, that's a risk with all the technology. Yeah.
Final question, please.
Philip Homburg, random hacker. So obviously this is a bad proposal, should be killed. So, but
Yes.
just thinking about it, so if you compare, say, well, the DMCA, which essentially has just a notice and takedown, then Google can develop their own content ID system. And if they got it wrong, then it's their problem, because, well, there's no legislation requiring to do them. It's only so if you now have legislation requiring there to be a content filter with specifics, then my question is, like, as we're sitting here, we're basically all rights holders, because everybody occasionally takes a picture and, well, you immediately become a copyright holder as soon as you take a picture. So is there any thought in this, in the proponents of this, in how to make that accessible? You mentioned a bit that maybe the rights holders would have to pay for the system, but it would be weird if, say, a small professional photographer would not have access to this system and that only Sony has access.
Yeah, so regardless of who needs to pay for it, I think that this is an issue as well, that only the larger companies, larger record labels, larger publishers will have access to the system. If you look at how Content ID works now, if you talk to artists, which I do sometimes, then they always explain me that the larger artists, so the well-known artists with a label, that they will be able to negotiate an agreement with YouTube. But the smaller ones are not able. So they can knock on the door with YouTube and YouTube just is deaf. They don't listen. That, of course, will be true as well if this upload filter is so if Content ID is extended to all services, that will not change. I think that this proposal also is not made with the smaller rights holders in mind. It's only made, it's drafted with the large publishers, like in Springer from Germany, in the back of their mind. They are the ones who are pushing for this type of legislation, and the small rights holders, you and me, they are nowhere near in this process, unfortunately.
But can a government do that? Or is that something that will also backfire as soon as the first small person stand up and say, well, you proposed this law and I'm excluded, so therefore this law must be invalid?
Well, I think that so that's a fairly legal question. I think that if the proposal would be enacted the way, so that it is not changed in any way and it's just approved like this, then I think that the small rights holders will have the right to knock on the door of a ISP or a content provider and ask for a share. But I guess that the content providers will just ignore you, and because they have a huge amount of lawyers and you don't, you will lose that battle anyway. Just like with Content ID right now.
Thank you, Rejo.
Thank you.
Is er